Hi everyone. Can everyone hear me all right? Lots of nodding. Okay, great. So just a little disclaimer, I've been having lots of issues with my internet over the last couple of days, so hopefully I won't cut out in the middle of the presentation, but if I do, I'll do my best to get back on. And Stephen will be recording this. Oh, it's already recording. All right, great. So that will be available afterwards, and in the next few days I'll also tidy up my notes, and I'm happy to circulate those as well, so please don't feel like you need to take any notes while we're doing this presentation. So firstly, I would like to acknowledge and pay my respects to the traditional custodians of the land on which we all meet this evening across Australia. For me specifically, I'm on the land of the Gadigal people of the Eora Nation, and I pay my respects to the First Peoples of this land and elders past, present and future. And I recognise that this land was and always will be Aboriginal and Torres Strait Islander land because sovereignty was never ceded. I also particularly want to acknowledge the traditional custodians of the land in the Northern Territory, where I had the privilege to work and live for a number of years, and it was my work there that was the impetus for the fellowship that I'm going to be talking about today, and also the Indigenous peoples in New Zealand and Canada. There are a couple of the countries that I travelled to as part of my fellowship. Having a look at who's dialed in, I think that most people are pretty familiar with OPCAT generally, so I think I'll just launch straight into what culturally appropriate OPCAT implementation might look like in Australia with respect to the criminal legal system, specifically focusing on the unique needs and experiences of Aboriginal and Torres Strait Islander people. You'll note that I focus heavily on the importance of proper consultation with Aboriginal and Torres Strait Islander people and their participation in OPCAT implementation. So I think it's really important to make clear from the outset that my fellowship research, it's based on my research, my experiences, but I wasn't able to actually follow best practice and undertake that robust consultation around the recommendations I've made and my findings. So I think that the report is very much just part of a broader process that should be happening across Australia rather than an endpoint. So I'll probably talk for about 45 minutes. I know that's a really long time. I kind of tried to condense 400 pages into something relatively short. And I guess at the end we have an opportunity for questions. There's lots of experts actually on this webinar, so please feel free to jump in as well. So given that only a few NPMs have been designated in Australia thus far, I think that one of the most pressing issues for everyone here in Australia at least is the designation process. The UN Subcommittee on Prevention of Torture, the SPT, has stated that NPM should be identified by an open, transparent and inclusive process, which involves a wide range of stakeholders, including civil society. I think that most people if not all people on this webinar would agree that it's essential that Aboriginal and Torres Strait Islander people, communities and Aboriginal community-controlled organisations, ACOs, are properly consulted, particularly in light of the gross overrepresentation of Aboriginal and Torres Strait Islander people in detention and the criminal legal system generally. It's also important to note that the UN Declaration on the Rights of Indigenous Peoples, UNDRIP, states that Indigenous peoples have the right to participate in decision-making in matters which would affect their rights, the representatives chosen by themselves in accordance with their own procedures. The reality is that Aboriginal and Torres Strait Islander people's potential to benefit from the prevention of torture and ill treatment under OPCAT, human rights instrument, would be compromised should NPMs not be culturally competent. And it's impossible to achieve this competency without robust consultation with and the effective participation of Aboriginal and Torres Strait Islander people. A failure to properly consult would inevitably result in NPMs not having the confidence of Aboriginal and Torres Strait Islander communities and ACOs, in turn compromising the NPM's ability to build future relationships which are essential to carrying out the NPM mandate. And of course, a lack of confidence in the NPM could also impact on Aboriginal and Torres Strait Islander detainees' willingness to engage with the NPM and staying at, and I'm very sorry, I know you're on this webinar and I apologise if I've mispronounced your name. As someone whose name is always mispronounced, has noted that it's hard to imagine how the NPM would be able to achieve anything if it did not have the trust of those deprived of their liberty. Consultations with Aboriginal and Torres Strait Islander people should be guided by existing governance structures, such as the Aboriginal Justice Agreement in Victoria. And I just want to note here that AJAs are particularly relevant in this context, given that they were first established many years ago in response to the Royal Commission into Aboriginal deaths in custody. And of course, that's very intimately linked to the detention oversight function of an NPM. I know that in the NT, there are negotiations and consultations around establishing an AJA up there too. I think it's also going to be really important. This is a really big topic, but I don't have too much time to spend on it today, unfortunately, but NPM designation, structure and operations may also need to be revisited once treaties have been finalised. Treaties are currently being negotiated in Victoria and the Northern Territory, and these treaties will give rise to obligations on state and territory governments, and that will be directly relevant to oversight of detention, namely sort of looking at whether those obligations are being respected by the detaining authorities and the governments, but it will also create obligations on the NPMs themselves. So for example, the New Zealand Ombudsman has said that he aims to ensure the principles of Te Tiriti o Waitangi are at the heart of the work and culture of his office. In order to do this, he and his staff must understand Māori concepts, perspectives and values, understand the treaty and barriers to its full realisation. Treaties may also, as in Canada, result in the administration of justice being or having the potential to be devolved to Indigenous peoples. So in these circumstances, sorry, NPMs will then have to consider how their mandate should be carried out while respecting that Indigenous people's right to self-determination, given that in the future a detaining authority may actually be operating under a self-governing First Nation. I think it's also really important to appreciate that consultation doesn't end with the establishment of the NPMs. It's an ongoing risk that the NPM will lose the confidence and trust of Aboriginal and Torres Strait Islander communities, and that there's a requirement that an NPM ensures that that risk is mitigated and demonstrates an ongoing commitment to consultation and co-design, as well as being receptive to advice or criticism. Of course, an NPM can't lose its independence throughout this process. It's a balancing act. Murray et al. Have said, in practice, independent bodies that sit in this official watchdog position can find it difficult to mediate this space, having to develop allies in what are often seen as opposing camps of NGOs and government, yet not being able to class themselves as either. This isn't an insurmountable challenge, but the issue does require careful consideration. For example, there will certainly be instances where ACOs are delivering services in places of detention. In relation to designating or establishing an NPM, I do want to note that in some jurisdictions it might be appropriate to establish a new body rather than designating an existing oversight body. The APT, the Association for the Prevention of Torture, that's an NGO based in Geneva, made a submission to the Australian Human Rights Commission OPCAT consultation. And in it, they said that where existing bodies fall short in any way, which is not readily reparable, a new body or bodies should be created to carry out NPM functions. And I think that's something that's quite important to consider when we're talking about culturally competent oversight of places in detention. Whether you support my recommendation or not that an Aboriginal inspectorate be set up, a new body in the NT, I do think that the gross overrepresentation of Aboriginal and Torres Strait Islander people in prison and in youth detention across Australia requires a tailored and targeted approach to prevent torture and ill treatment. So moving on to a topic that is the interest of many people in the OPCAT network is relationships with civil society. The SPT has explicitly stated that an NPM should take benefit from cooperation with civil society, universities and qualified experts. And in fact, in one of their country visit reports, they recommended that the NPM there redouble its efforts to promote trust and build a climate of constructive cooperation with civil society. The SPT has also recommended that NPMs pay special attention to developing relations with civil society members devoted to dealing with vulnerable groups. So in the Australian context, that's clearly going to be ACOs, among other organisations as well. Civil society, both organisations and individuals, play a complementary role to that of an NPM in the prevention of torture and ill treatment of detained people. And they're relevant stakeholders that should be properly engaged. Civil society may cooperate with an NPM in a number of ways, including by raising the profile of the NPM's mandate and work, both among the public and people who are detained, delivering training to NPM staff, contributing to the development of the inspection framework and expectations or standards that are used, providing information to the NPM that could assist in developing a strategy for inspections and in preparation for inspections at particular sites, incorporating the NPM's findings and recommendations in its own work on torture prevention, monitoring implementation of the NPM's recommendations, working to prevent reprisals against those who engage with the NPM, and evaluating the efficacy of the NPM's work. So there's a whole range of ways civil society and particularly ACOs can be involved in this space in the future and currently. There are different approaches to building relationships with civil society. This can be formal or informal cooperation. For example, NPMs might hold regular meetings with ACOs or have annual forums in order to discuss issues of concern, the annual reports, recommendations. NPMs could consider sending embargoed reports to civil society organisations to give them opportunities to draft media releases, for example, in anticipation of NPMs publicly releasing their reports. STAINIT does highlight that an NPM's unique status is based on its ability to build relationships with detaining authorities, in contrast to an NGO, and it is this that makes it potentially more powerful than an NGO. And I do think that's something that civil society and ACOs should be mindful of going forward, because it's inevitable there'll be times of conflict or disappointment or frustration. So it's kind of respecting that unique role that an NPM can play that perhaps an NGO can't. Australia being a federation, it's important to also consider how the NPMs across different states and territories might work with each other. I'm not sure where the Australian governments are in relation to the proposed intergovernmental agreement, but we know that there exist current agreements between different jurisdictions that will be relevant to NPMs. For example, WA, South Australia and the NT have a prison service MOU, which outlines responsibilities including prisoner transfers. And also specifically for Aboriginal and Torres Strait Islander people, it's important to recall that state and territory borders don't reflect the cultural and familial ties of Aboriginal and Torres Strait Islander communities living in different Australian jurisdictions. So considering that fluidity across the borders, I think that makes it even more important for NPMs in different jurisdictions to build strong relationships. NPM should also consider conducting joint inspections and thematic inquiries with NPMs across Australian jurisdictions, particularly in relation to the experiences of Aboriginal and Torres Strait Islander detainees. Adopting this approach would enable comparisons across jurisdictions, identifying universal issues of concern, divergent practices, best practices, and of course, the more NPMs you have coming to the same findings, making the same recommendations, it's more persuasive, and also you have the opportunity of reaching a broader audience as well. I mean, there's plenty of things that NPMs could look at, but some examples of themes might be access to cultural activities or leave to attend significant cultural events such as ceremonies or funerals. For example, Queensland and the Northern Territory and WA, the transfer or transportation of detained people between police stations and urban prisons and circuit court out in the remote communities. How intergenerational trauma affects Aboriginal and Torres Strait Islander people's experience of detention. One interesting example I came across was the UK's HMIP, Her Majesty's Inspectorate of Prisons. They did a thematic report on race relations in prisons. So it gives you a bit of an idea of what sort of themes NPMs could look at in Australia. UK NPMs also have a number of subgroups. So for example, a number of NPMs might focus, have a subgroup focusing on children and young people, and I could definitely see a space for something similar in Australia, focusing on Aboriginal and Torres Strait Islander people. And I guess I also just want to highlight NATSLs, for those of you who aren't from Australia, that's the peak body for the Aboriginal Torres Strait Islander legal services here. They made a submission to the Australian Human Rights Commission consultation on OPCAT, saying that it's essential that NPM bodies and standards they adopt are informed by human rights-based approach. In developing this approach, they recommended that NPM bodies are required to liaise closely with human rights bodies, and they particularly recommended the Aboriginal and Torres Strait Islander Social Justice Commissioner as a key stakeholder. In terms of overseas examples I came across, I think really great practice from Scotland. Her Majesty's Inspectorate of Prisons Scotland conducts joint inspections with the Scottish Human Rights Commission. So I think that's a really great example of bringing that human rights expertise that perhaps other NPM bodies might not have. So now turning to NPM staffing. So OPCAT requires that states in relation to NPM's personnel shall strive for gender balance and that adequate representation of ethnic and minority groups in the country occurs. Murray et al. Found that in some jurisdictions, whether the NPM has members from a particular ethnic group on its membership can be crucial to its legitimacy. And I think it's difficult, probably impossible, to imagine an NPM in Australia without having that significant Aboriginal and Torres Strait Islander representation, achieving that legitimacy among the Aboriginal and Torres Strait Islander community. During my research, I also came across the APT's report from a regional forum on the OPCAT in Latin America. And a recommendation from that was that NPM should ensure to include Indigenous persons or persons having relevant expertise included in the composition. NATSL's submission again to the Human Rights Commission consultation emphasised that there should be legislation to give effect to having that multidisciplinary and diverse expertise, including gender balance and Aboriginal and Torres Strait Islander representation. And the report itself noted the importance of having representation. And for me personally, as part of my fellowship, I was lucky enough to shadow a number of inspections undertaken by NPMs, and the New Zealand Children's Commission inspection that I shadowed, half the team was Māori, the person leading the inspection was Māori, so I think that's a really great example of having genuine representation. NPMs, I think, will need to be proactive about recruiting Aboriginal and Torres Strait Islander people. And of course, in order to attract candidates, there needs to, we go back to that, having the trust and confidence in that NPM. That will be really important. It will also be important that NPMs are culturally safe workplaces. And that can be understood as a place where there is no assault, challenge, or denial of identity of who people are and what they need. It's about shared respect, shared meaning, shared knowledge and experience of learning together with dignity and truly listening. So I think that's a really important thing to be mindful of going forward. OPCAT also requires that states parties shall take the necessary measures to ensure that the experts of the NPM have the required capabilities and professional knowledge. So this includes lawyers, medical professionals, psychologists, social workers. Multidisciplinary teams are necessary not only to evaluate the evidence and to reach objective conclusions to support an NPM's findings, but they can also better make solution suggestive recommendations. And of course, an NPM might need to engage consultants if they don't have that expertise on staff. In my report, I recommended that NPMs are comprised of Aboriginal and Torres Strait Islander staff across disciplines. So rather than just having one person, for example, on your inspection who's Aboriginal or Torres Strait Islander, ensuring that your team is comprised in such a way that every single aspect of detention can be viewed through this culturally appropriate lens and an expert lens. You need both. In NAJA, so NAJA, again, for those of you overseas, is the Aboriginal Legal Service in the Northern Territory. So their submission to the Human Rights Commission consultation stated that where health or mental health professionals should be included on visiting teams, such staff would need expertise in terms of Aboriginal and Torres Strait Islander people's perspectives. And they gave the example of psychological tools that have been used to assess risk that are not appropriate for Aboriginal and Torres Strait Islander people. And just to sort of highlight why it's so important to have this particular expertise, a review of deaths in custody over the last 2 decades after the Royal Commission into Aboriginal deaths in custody found that the number of Aboriginal deaths in custody had increased over the past 5 years, and that most of the deaths were due to natural causes. And that review said it's a particularly concerning trend in the justice system that must be addressed through the provision of culturally sensitive and supportive healthcare. So you need to have an NPM that can actually properly assess whether that's happening. Including staff or consultants with lived experience accords with the principle that detainees' experience of detention is central to the NPM's work. NATSLs and the APT submissions to the Human Rights Commission, consultation, and the report itself recognise that the most effective NPM bodies will work collaboratively with people with lived experiences of the places of detention that are being inspected. Including staff with lived experience improves the NPM's ability to effectively carry out its mandate by increasing its ability to genuinely appreciate the culture of an institution. And I think that's a harder thing to do as an oversight body, but also through challenging assumptions. So, for example, an APT symposium on monitoring psychiatric institutions found that. It can also assist an NPM to build a better understanding of what should be classified as torture and cruel, inhuman, or degrading treatment or punishment. a global forum on OPCAT had found, reached a conclusion that an inclusive approach involves engaging victims, service users and former detainees, and this can ensure a victim-centred approach to torture prevention, focusing on the person, their rehabilitation, their perspective of what can be done to stop torture from occurring in the first place. An APT report from an Npm symposium on addressing children's vulnerabilities in detention noted also that one of the suggestions that came out was that children and young people should also be involved in the work of NPMs. I don't know if anyone else has a different experience here, but to date, I'm aware of NPMs including people with lived experience in relation to mental health services like the New Zealand Ombudsman, but not really in the prison context, although NGOs frequently work with people with lived experience. And I think if you're looking at how, in terms of providing appropriate support and valuing the contribution of people with lived experience, Sisters Inside, their submission to the Human Rights Commission consultation addresses this point really well. I'm of the view that having a criminal record shouldn't automatically exclude someone from participating in the work of the NPM, but of course you need to have guidelines in place recognising that the NPM's mandate involves contact with vulnerable people, including children and survivors of domestic violence, and of course access to confidential and sensitive information, including the personal medical records of people who are detained. So, moving on to the inspection itself. The Istanbul Protocol has said that unique cultural, social, and political implications that torture has for each individual influence his or her ability to describe and speak about it. There are important factors that contribute to the impact that torture inflicts psychologically and socially, and that must be considered when performing an evaluation of an individual from another culture. So it's really important that NPM staff ensure that a trauma-informed approach is effective cross-culturally. And that would include recognising the impact of intergenerational trauma when engaging with Aboriginal and Torres Strait Islander detainees, and also when speaking with detained people, inspectors should recognise the cultural implications of ill treatment may affect survivors' ability to truly discuss their experiences. In good practice, Her Majesty's Inspectorate of Prisons conducts detainee surveys, which enable it to compare responses across different groups. So they can compare experiences of detained people, for example, particularly Black and minority ethnic detained people. And I think adopting a similar approach in Australia would really assist NPMs to identify which aspects of detention have a disproportionate or different impact on Aboriginal and Torres Strait Islander detained people, better enabling them to make targeted and accurate recommendations. But having said that, I think we would need to adapt that to the Australian context. I can certainly say in the NT where I worked, written surveys would not be an appropriate approach. So in my report, I recommended that NPMs, it's more time consuming, but I think this is really important that they hold detainee focus groups. That can also be an opportunity to provide information about the NPM's work, ensure that proper informed consent is obtained. Using the assistance of interpreters would definitely be necessary. And then either people can complete the forms themselves or have the assistance of NPM staff. This will be relevant to quite a number of jurisdictions across Australia. So I just want to make a couple of notes around working with interpreters. So in my report, I recommended that detaining authorities just provide regular updates about the preferred language of people currently in detention, because you need to have that information so you can book interpreters in advance, but by the same token, you want to be able to conduct unannounced visits. So just getting that regular information allows proper preparation. I think staff need to be proficient at working with interpreters. I know in the Territory, the AIS provides great training for all lawyers. I don't know if there's something similar in other jurisdictions. I think NPM should consider developing some plain English subject matter dictionaries or glossaries. A lot of the concepts, legal concepts, can be quite difficult to understand. And I also think that NPM should take the time to provide technical training to interpreters on its mandate, on how it conducts its inspections, and again, addressing those sort of technical terms and concepts. In terms of the NPM reports, I'm of the view that they should be made publicly available, but also in light of the overrepresentation of Aboriginal and Torres Strait Islander people in the criminal legal system and in detention, I think that NPMs actually have a responsibility to make a specific targeted effort to inform Aboriginal and Torres Strait Islander communities about their findings and recommendations. I think this is important to promote the work of the NPM, to ensure the NPM is accountable. We talk a lot about the accountability of detaining authorities, but I actually think the NPMs need to be held accountable in terms of their cultural competency, in terms of their compliance with OPCAT. So I think, yeah, the targeted approach is important in terms of accountability of both detaining authorities and the NPMs themselves. And ultimately, if the NPM isn't prioritising ensuring that Aboriginal and Torres Strait Islander people have access to the same information as non-Aboriginal people, its approach effectively amounts to exclusion and perpetuating Aboriginal and Torres Strait Islander people's marginalisation and disempowerment in a criminal legal system that disproportionately impacts on their lives and communities. So this brings us to, how does an NPM look at prevention of ill treatment? What does that actually mean? So the SPT states that there is more to the prevention of torture and ill treatment than compliance with legal commitments. In this sense, the prevention of torture and ill treatment embraces, or should embrace, as many as possible of those things which in a given situation can contribute towards the lessening of the likelihood or risk of torture or ill treatment occurring. Burke et al. Describe prevention as an action taken with a view to proactively creating an environment where torture is less likely to happen, a holistic view focusing on the root causes of torture and the complex factors allowing torture to happen rather than on the individual level of violations. And the SPT has identified that the risk of torture is affected by an incredibly broad range of factors, including the general level of enjoyment of human rights and the rule of law, levels of poverty, social exclusion, corruption, discrimination. And it stated that preventive work requires a holistic, sensitive, and deep understanding of the context in which an NPM is located. The NPM must therefore look at all levels where the causes might be found, including the broader legal policy and institutional frameworks. So what does this mean in practice? For example, recognising that the risk of torture and ill treatment increases with overcrowding. It would be appropriate for an NPM to consider the factors that have led to the overrepresentation of Aboriginal and Torres Strait Islander people in prisons. The SPT itself noted Māori overrepresentation during its visit to New Zealand, and a culturally competent NPM would also take into account Aboriginal and Torres Strait Islander community-driven solutions, including alternatives to custodial dispositions and opportunities for diversion. As the SPT has noted, for many Indigenous persons, imprisonment itself constitutes cruel, inhuman and degrading treatment and even a form of torture. Strengthening the Indigenous justice system and its forms of social control and punishment for violating its laws could therefore serve to prevent torture and cruel, inhuman or degrading treatment of Indigenous persons. So an example of good practice I came across, again, the New Zealand Children's Commissioner, which has emphasised that legislation should reflect a Māori worldview. As the NPM is establishing its inspection framework, its expectations and standards, and designs the surveys that it will use in places of detention, it's essential that it consults with Aboriginal and Torres Strait Islander communities and ACOs to ensure that the standards it's using, the data it's collecting, will advance this objective of preventing the torture and ill treatment of Aboriginal and Torres Strait Islander detained people. At the UN Permanent Forum on Indigenous Issues, Indigenous representatives have raised concerns about the relevance of existing statistical frameworks for reflecting their worldviews, and have highlighted their lack of participation in data collection processes and governance. As a result, the collection of data on Indigenous peoples is viewed as primarily serving government requirements rather than supporting Indigenous peoples' development agendas. So in the context of NPMs, with the assistance of ACOs and Aboriginal and Torres Strait Islander communities, an NPM would be a better place to crystallise what those relevant concepts might be into the survey questions, to facilitate collecting data that has value to the Aboriginal and Torres Strait Islander community, but also to detainees. Robust consultation can assist an NPM to collect data and evidence that can be genuinely useful in assessing the risk of torture and ill treatment, appreciating that just as women and children's needs are unique, and the risks of torture and ill treatment differ in certain respects for those groups, so are certain needs and risks unique to Aboriginal and Torres Strait Islander people. The NPM should commit to empowering Aboriginal and Torres Strait Islander people to guide the NPM in accurately identifying those risks. And importantly, NPM should recognise that Aboriginal and Torres Strait Islander people's culture is both a strength and a protective factor. I think often discussions in this space focus on the deficit rather than strength and resilience. So that's going to be essential to the NPM's work. A robust appraisal of the cultural appropriateness of a place of detention requires an NPM to look beyond those aspects of detention that seem the most obvious place to start. So availability of cultural programs, use of interpreters, hiring Aboriginal and Torres Strait Islander staff. Of course, those are important considerations, but they should really only be a starting point, not the end point as well. In my report, I said that every single aspect of detention has to be assessed through this lens, this culturally appropriate lens. Just as gender mainstreaming, for example, is an accepted practice, so should the practice of assessing every single aspect of detention through a culturally appropriate lens. The APT has observed that an inclusive approach to inspection involves ensuring that the issues of vulnerable groups are mainstreamed into preventive work. Again, in terms of good practice, I would refer you to the New Zealand Children's Commission overarching Māori framework, Mana Mokopuna. And in Australia, actually, the Western Australian Office of the Inspector of Custodial Services has a specific set of standards and considerations for Aboriginal people. Although it's somewhat dated, it might need to be reviewed, but that's good practice too. As I've already mentioned, obligations under future treaties will be relevant. So for example, in New Zealand, the Human Rights Commission, which is the coordinating NPM, has taken notice of Waitangi Tribunal decisions. Also, in drafting its expectations or standards, NPMs should be guided by UNDRIP, which states that the rights recognised herein constitute the minimum standards for the survival, dignity and well-being of the Indigenous peoples of the world. There are a number of articles that would be relevant. For example, the right to manifest, practice, develop and teach their spiritual and religious traditions, customs and ceremonies. And in fact, the SPT in its 6th annual report considered the issue of the rights of detained Indigenous people noting that Indigenous peoples should be placed in detention centres nearest to their communities and their families, so they're able to receive frequent visits and follow their traditional practices and customs, which will minimise the risk of their being isolated from their relatives, culture and religion. So the next thing I want to talk about is systemic racism, which has very much been in the news lately with the Black Lives Matter movement in the US, but also in Australia. And in fact, recently the Public Health Association Australia has stated that it is indisputable that racism is a real and ever-present public health issue. Racism in Australia obviously precedes COVID-19 and has a massive continuing impact on the health and well-being of Aboriginal and Torres Strait Islander people. In my report, I concluded that it's essential that when assessing the risk of torture and ill treatment of Aboriginal and Torres Strait Islander detainees, an NPM must include in its expectation that there is an absence of systemic racism, both at the detention sites, but also within the detaining authorities, so Department of Corrections or other. And in fact, taking such an approach would align with the Special Rapporteur on Torture's position that states are under a heightened obligation to protect vulnerable persons from abuse and should interpret the torture protection framework against the background of other human rights norms, such as those developed to eliminate racial discrimination. The Special Rapporteur on Torture has described places of detention as particularly disempowering environments that combine power, asymmetry, stigmatization and discrimination with other forms of vulnerability. The risks of marginalization associated with detention are further exacerbated in the case of persons with particular vulnerabilities. And it's recognized that groups or persons that are marginalized or discriminated against in society, including Indigenous peoples, are particularly vulnerable to abuse and more likely to be subjected to torture or other forms of ill treatment when deprived of their liberty. The UN ODC has also stated that discrimination against Indigenous minorities in the closed and coercive environment of prisons can lead to violence against such groups by other prisoners and their harsher treatment by prison staff. So part of the work of an NPM is to kind of look at these root causes as well and look at the culture and the place of detention. Stevens has described institutional culture as the shared assumptions and values of staff and detainees which guide behaviour within the detaining organisation. These are the shared attitudes about what is important within the detaining organisation, how problems are solved and what types of behaviour is acceptable. Staff working in places of detention are socialised into the culture of the organisation and it can be difficult for them to step back and assess it objectively or break out of it. He noted that culture in detention develops gradually over time through a complex mix of factors internal and external to the organisation. These include the idea of what the organisation does and why. This can be set by legislation and public policies as well as by management and explicit policies. And I'll emphasise this, just as important are unwritten rules and informal endorsements by managers which motivate the behaviour of staff. So that's going to be more complex to monitor or to inspect, but if we're talking about what these root causes are when we're trying to mitigate the risks, that needs to be considered. The NPM should also consider the ongoing impact of colonisation on the criminal legal system, particularly in relation to places of detention and the detaining authorities, and the legacy of systemic human rights abuses that have occurred in Australia. NPMs must have an understanding of intergenerational trauma and Aboriginal and Torres Strait Islander people's contemporary relationship to the criminal legal system. Although inspections assess a situation in a place of detention at one point in time, NPMs really need to understand the legacy of Australia's colonial history in order to accurately identify the conditions and treatment in detention and their root causes that constitute or have the potential to lead to torture or ill treatment. So that's going to be relevant when doing assessments at site level, but also when looking more broadly at risk factors such as overrepresentation. In the Regional Forum on the OPCAT in Latin America outcome report, the APT wrote that the colonial past of Latin America was characterized by systemic human rights violations, including racism and discrimination against Indigenous peoples. This past is still present in the legal, political, and social realms, as well as in the mindset and attitudes of people in Latin American societies today. Public institutions such as prisons are no exception to this, with a number of serious consequences for Indigenous persons who find themselves in prison. And then they note that in the case of Indigenous women, a double vulnerability exists. In Canada, which is one of the countries I visited as part of my fellowship, Gladue principles are applied during sentencing. I don't want to spend too much time on this, but basically those principles they acknowledge the many reports and commissions that have intimately tied the overrepresentation of Indigenous people in the criminal legal system with colonisation's legacy. And what I found really interesting, I'd known about that before I went there, but I didn't realise that Correctional Service Canada, which is the federal correctional services, also applies Gladue principles in its decision-making around issues pertaining to security and retained liberty. So they consider Gladue principles when they look at security classification, placement in prisons, transfer, segregation, disciplinary procedures. So of course we don't have that approach in Australia, but NPMs can definitely include in its expectations and standards that acknowledgement of the impacts of colonisation when it's assessing the treatment of people in detention. I think probably of all the research that I did, sort of not during the actual fellowship, but what I read afterwards, that the thing that kind of stayed with me the most was Giffard's statement in the Torture Reporting Handbook. It says, one particularly significant factor which may affect an assessment of the severity of the degree or suffering experienced is that of culture. It is important to be aware that different cultures, and indeed individuals within a particular culture, have different perceptions of what amounts to torture. This can be relevant in two ways. And particularly the one I'd like to focus on is, it can mean that behaviour which is thought of as torture by a culture or individual victim may not normally constitute torture in the eyes of international bodies. NAJA, in its submission to the Human Rights Commission consultation, said that it's important to recognise that many Aboriginal people have different worldviews and interpretations of words can differ substantially. They noted at a foundational level a concern raised by community about the lack of respect towards Aboriginal laws and perspectives, which is evident both within prison and detention facilities and through the operation of the Western legal system. This can be degrading towards Aboriginal people and damage the relationship between Aboriginal communities and the law. Again, the APT's report from the Regional Forum on OPCAT in Latin America highlighted that the main structural issue is the fact that the very institution of a prison is alien to most Indigenous cultures, and that institutions are not designed in light of the needs of Indigenous peoples. So I guess I just want to conclude on the importance of NPMs appreciating that an Aboriginal and Torres Strait Islander perspective of what constitutes torture or cruel, inhuman or degrading treatment or punishment may diverge from that of non-Indigenous people, and that the suffering experienced by an individual, the significance that they attribute to particular conduct or a situation in detention, their emotional response, all of these things are going to be determined in part, at least, by how their culture shapes their worldview. NPMs should appreciate that Aboriginal people may experience imprisonment differently, and that the long-term impact of torture and ill treatment can be shaped by survivors' culture and the historic political context of ill treatment, including the history of colonisation. Okay, and that brings me to the end of my, longer than 45-minute presentation, sorry. I don't know if anyone has any questions.
I might start if that's okay.
Yep.
you made mention in regards to the Northern Territory, the recommendation that an Aboriginal inspectorate be produced to be the NPM, and obviously that is in contrast to the views of the Royal Commission. Can you talk a bit more about that, and also whether you think a similar body would need to be set up in the other states and territories?
That's a tricky question. Thanks, David. So part of the reason I applied to do the fellowship was I was working in the Territory when the Royal Commission was on. I actually gave evidence, written and oral evidence, and I certainly didn't expect to depart from the Royal Commission recommendations. And I kind of went back and forth about whether I should include this in my report, and in the end I decided to just put forward what I think would be the ideal model, and leave it to others to make those decisions. But I think a big part of what made me think about this, and actually I added Geneva to the end of my Churchill Fellowship to speak to the APT and the OMCT, because I was worried that this recommendation might, there might be some issues around that from an international perspective. But I've worked as a criminal defence lawyer for a generous legal service and for an Aboriginal legal service, and the difference is stark. When you work for an Aboriginal organisation, an ACO, I can see someone asked what an ACO is. It's an Aboriginal Community Controlled Organisation. So when you work for an ACO, and obviously this wouldn't be for an NPM because it has to be a statutory body, but you report to an Aboriginal board. The entire purpose, the structure, the foundations of that organisation is geared towards providing a culturally competent service to Aboriginal people, or in other jurisdictions, Aboriginal Torres Strait Islander people. So that's a real strength. I think that there's always a risk that if you have a generalist body, that if it's not supported by the structure itself, sometimes the Aboriginal and Torres Strait Islander people working in that organisation, that they kind of take on that cultural load almost. They have to provide the cultural competency of the entire organisation regardless of where they fall. So they might not be in a management position, but then they kind of do their job, and on top of that they provide the cultural competency for the organisation, which can be ineffective, but also quite an unfair ask of individuals. And I think also the reality is that the Royal Commission and I were looking at different things. So they were focusing very much on children. So whereas I was looking at the entire sort of criminal legal system, so adult prisons as well. So we're kind of coming from a different perspective as well. So it's probably not that surprising that we came to different conclusions. And actually I have a chapter in my report where I really kind of go through the Royal Commission, it's the evidence that was put to it, or put before it, its findings and recommendations on that. So it goes into more detail. Also, I think obviously we have overrepresentation across all jurisdictions, but in the Territory it's particularly bad. So for those of you who aren't aware, the general population is about 33% is Aboriginal. In the prisons, 84% of people are Aboriginal, and in youth detention, it's between 97 to 100%. I mean, I've never seen a non-Indigenous kid, to be honest, when I was in Dondale. So when almost everyone who you're going to be is going to fall within your mandate if you're an NPM, for me it also makes sense to have that sort of really targeted approach.
Thanks very much, Andreea. And I think just from personal experience working for the WA Inspectorate with one Aboriginal staff member, I can agree on that point about that the staff member having to hold all the cultural competency, and from experience the need to support that staff member because their role isn't confined within the 9 to 5, it extends beyond it, and there needs to be a recognition of that. I think Alina has a question, she's raised her hand.
Yeah, thank you very much. Thank you, Andreea, for a very interesting presentation. The question I wanted to ask you is a little bit, it's fairly academic actually at this point in time where we are with OPCAT, and I apologize for that, but it comes from the very long time when I did detailed research on optional protocol, which is now about some 10 years ago already, shame to admit, but there we are. And it comes back to Article 18.2 of OPCAT, which you mentioned, which talks about the composition of OPCAT and the need for inclusion of minority and ethnic group representation. And when we were doing work on Latin America in particular, we were challenged by Indigenous groups saying, why doesn't Article 18.2 specifically mention Indigenous communities? Because, of course, minority representation, ethnic diversity representation does not always equate with Indigenous people's representation. It's very different. And in many countries, this not so subtle difference is simply skipped over by saying, well, we do have minority representation, we do have ethnic diversity, which doesn't mean Indigenous representation. And it made me reflect also, and since then I have been every now and then coming back to the issue of drafting OPCAT in the first place and the Indigenous voices in this drafting process, and the fundamental question of whether that treaty, whether SPT, NPM as we know it now, the system of prevention that is put in place by OPCAT would be different, and to what extent different, if those voices were present when the treaty was drafted. And I know this is a very fundamental question to ask, but given the detail that you have gone into looking into Indigenous perception of this instrument, I can't help myself but ask that question of you. How different do you think OPCAT would be, should be, in order to accommodate that?
Look, I think it's hard to know. I don't know who was involved, to be honest, in the drafting process, but I imagine that OPCAT would look different if Indigenous people had not only been involved, but I think also their voice had been really respected, because there's a difference between being involved and consulted and really having your views incorporated. But yeah, I think it definitely could have looked different. I think there's also a growing understanding internationally that so often what happens is you have like white people in one category and then everyone else is a person of color. And I think there's this growing understanding now internationally that people have different experiences, and the experiences of Indigenous people are unique and do need to be given that special attention. It doesn't really make sense to say, oh, well, we've covered the needs. I mean, it doesn't make sense at all to say we've considered the needs of other minorities, and so we've kind of covered the needs of Indigenous peoples. And I think it's, again, coming back to that understanding of the history of colonisation and the very unique experience of racism. I can definitely say, at least in Australia, that Aboriginal and Torres Strait Islander people experience. So, I mean, if you're open to redrafting the OPCAT, go for it. But I think like we can definitely use what we have there to make sure that in the Australian context and in New Zealand and in Canada, when it finally ratifies OPCAT, that those views are incorporated. I don't know if anyone else has a question. I've probably fatigued everyone with my really long presentation.
I've got a question. Can you hear me?
Yeah.
Great. Jenny from Just for Invest New South Wales. Thank you. I just wanted to pick up on what you mentioned on Gladue reports and considerations in detention and how that's actually playing out in Canada.
Yeah, so I was surprised because I didn't realise that was the case. So for those of you who don't know, Gladue reports were, or as they're sometimes known, Aboriginal social history reports. They're in Canada. They're used, for sentencing, for bail, for parole considerations, and really it's supposed to be a mechanism by which to address the overrepresentation of Indigenous people there, recognising sort of this ongoing legacy of colonisation and the disadvantage and intergenerational trauma experienced by Indigenous people today. So Correctional Services Canada is supposed to take those considerations take into account those considerations when they're looking at a whole raft of decisions that they're making in relation to detained Indigenous people. So, of course, there's always the potential that those Aboriginal social history or Gladue reports are misused and then used to evaluate risk, which is not what they're supposed to do. But it's about providing fairer outcomes and being, I suppose, culturally appropriate in a way when deciding, for example, what prison a person should be placed in. So I guess considerations around, I've mentioned in the presentation, making sure that you're close to country and your family and your community. So I guess, again, thinking about the NT context, I could definitely see a relevance when we're you often see kids from Alice Springs are kept in Dondale, and so they're really far from their families. So they can't, perhaps they're not speaking their language, they don't have family visits, it's a disconnection from their families, their communities, their culture. So that would be an instance where it might be used. Also, we've talked, I've talked quite a bit today about how Indigenous people experience prison differently, so that would also be relevant when we're talking around segregation and isolation, or disciplinary procedures. So kind of taking into account a person's Aboriginality and ensuring that those approaches are as appropriate as they possibly can be. Obviously, a lot of these procedures and disciplinary procedures and segregation, etc., are not appropriate under any circumstances. Does that answer your question?
I think Alex had a question.
Yes, I did have a question. It's sort of related to some of the earlier discussion, and maybe it's already been answered, but briefly, the question is, a lot of the thorough research that you've done uncovers this whole range of factors that affect each other and can and should be taken into account. And to me, it paints a picture of a really complex task to consider all these different things in the role of an NPM. And so I'm wondering, do you have any sort of insight into how to make it work in practice so that it doesn't become a massive box ticking exercise to say we've considered this, and this? Like, how do you actually get to what really matters and make sure that we're monitoring the real experience of people? As I said, I think you've already answered this question.
No, thanks for the question. And I'll just say, for those of you who have seen the report, Alex works at ARDS in the Northern Territory and helped me, along with some of his colleagues, translate the executive summary. But I think it is a big task, and I think that it's going to take a while to get right. And it's going to be a process. And I think that it's about, I think it's more about committing to that process and committing to working with and properly consulting with Aboriginal and Torres Strait Islander communities and ACOs. And I think there'll be an element of hit and miss, like we'll all just learn through the process as well. I think particularly because OPCAT's a completely new idea. So many of the oversight bodies are used to their oversight being about conducting investigations, adjudicating complaints, rather than really working in this prevention space. But for me, if literally the only thing anyone takes away from today, consultation and meaningful consultation and taking on board people's views, because asking non-Indigenous people to get it right, it just won't happen without those views. So I think making a proper commitment to that, properly resourcing the consultation and setting up this whole sort of all the NPMs, I think that there needs to be some proper funding allocated to that. And then obviously proper funding in terms of the NPM's operations going forward as well. And I guess if you came in a little bit late, Alex, like I've already said, you know, these are very much just my views based on my experience and the research that I've done. Before I published, I had like a quick chat to a couple of the ACOs in the NT. But for me, this report is a conversation piece. It's not the end result. And if Aboriginal and Torres Strait Islander people and communities and ACOs are consulted on this, they may take issue with parts of it, and that's to be expected.
Does anyone have any last minute questions?
Okay. Well, I guess everyone has my email. So feel free to contact me if you have any other questions. Stephen will hopefully share this recording. Once I tidy up my notes, I can send them through as well to everyone. I also added in the email that I sent today a submission that was done last week to the UN Special Rapporteur on the Rights of Indigenous Peoples. So it briefly mentions culturally appropriate OPCAT implementation. So that might be something you want to refer to as well.
I think you can all join me in thanking Andreea for this presentation, which has been incredibly enlightening and an incredible needed piece of work that she's put together. So thank you, Andreea, for spending the time with us and enlightening us on this topic.
Okay. Well, thank you for all tuning in, and I'm sorry I went over time. Okay. Bye, everyone.
Bye.